Hello, my name is Cassandra Dorn, and I'm a certified financial planner with Provident Financial Consultants. Thank you for taking the time to join me today. I plan on discussing beneficiary designations and how important they are with regards to your investments and your retirement savings accounts. It's important to review beneficiaries from time to time, but especially after large life events such as a divorce or a death in the family. You want to make sure your beneficiary designations are the way you intend them to be. So if something does happen to you, there is a smooth transition with your estate plan. So with that being said, let's jump into the presentation.
Today's presentation is entitled Cautionary Tales from the World of Legacy Planning and How Beneficiary Reviews Can Help You Avoid Missteps. My goal today is to make you aware of some of the problems that stem from not updating beneficiaries on your investment accounts so that you can take immediate steps to make sure these problems don't affect your plans and avoid becoming a cautionary tale. With that in mind, our agenda for today is why regular beneficiary reviews are so important, the pitfalls of not performing regular beneficiary reviews, and how a beneficiary review can streamline your entire legacy plan. Let's start with why beneficiary reviews are so important. We all know the answer. I just said it 2 slides ago. But can we all agree there is a huge difference between knowing something and doing something? All the knowing in the world usually doesn't amount to much unless you actually do something with that knowledge. But no matter how these errors come about, more often than not, they are fixable if they are caught before you pass. It's a very simple question. Do you want to fix this potential problem today and make sure your money goes to whom you want and when you want? Or do you want this to become a permanent problem that no one can fix after you're gone? So let's share some stories that don't have the endings these clients and their families were expecting. But remember, these stories are meant to serve as cautionary tales. By being proactive, you can avoid the pitfalls of miscommunication and misunderstanding. Let's start with a story about a newly married couple. In this story, a 40-year-old couple, the husband was married previously. The wife was never married. They were married 6 weeks when the husband suddenly and unexpectedly passed away. The wife hadn't even sent out thank you notes from the wedding before she was sending out obituary notes. He had a qualified plan, or a retirement plan, and he never changed the beneficiary on it after they were married, although he did update his will. However, as you know, beneficiary designations supersede anything in the will. So therefore, we had no choice but to pay out the qualified or the retirement asset to the first wife. It was a sad story with an unhappy ending. I don't know these people, but it's sad to hear about the loss of anyone so young and so recently married. I would not presume to speak for these people or know their thoughts, but it is a very common to experience a life change like a marriage and think you have all the time in the world to make changes to your legacy planning. You can always get to it tomorrow, but very few of us know exactly how much time we have left on this planet. It's also very common for people who don't have legal or financial backgrounds to not understand that the will does not trump or supersede the rules regarding qualified retirement plans. Here, the qualified plan custodian had to distribute to the ex-wife because it must distribute to whomever was listed as a beneficiary under the plan documentation. Those are the rules for that particular asset, regardless of what the will said. Granted, the odds of passing away suddenly at age 40 or 6 weeks after you're married, or both, are statistically low. But potential risk to your spouse by leaving your ex-wife listed as your 401k beneficiary is enormous. This is why we encourage our clients to come to us well in advance of any planned life change, like a marriage or a new child, so that beneficiary designations can be updated to reflect new family situation as soon as it occurs. On a side note, we also encourage our clients to bring in any investment statements that they have, whether they're intending to move those investments to us or not, so we can review those beneficiaries. I just had a couple in that he was working for a company before he got married. This was 20 years ago. And I asked him simply, did you ever update that small IRA to add your wife? And he looked at me and said, I don't know. So it was a good reminder that no matter how far back you need to go, you need to review every investment account to make sure those beneficiaries are updated the way that you want them to be. Here's another story, a legal case actually, from the U.S. Supreme Court back in 2009, and this is Kennedy versus DuPont. William, or Bill, and Liz Kennedy were married, while Bill was an employee of DuPont and a participant in its savings and investment plan. Bill named Liz as the sole beneficiary on his plan benefits. The couple then divorced in 1994. The divorce decree terminated any of Liz's rights to Bill's pension or retirement benefits, but Bill never changed his beneficiary on the plan. When he died in 2001, his estate, via his daughter Carrie, made a demand for the plan funds based on the domestic relations orders. So what wound up happening? Even though Liz signed the divorce decree and waived rights to Bill's retirement plan, she was still the named beneficiary, and the plan administrator had to pass the assets to her. The DuPont plan administrator refused and dispersed the funds to Liz in reliance on Bill's beneficiary designation form. The ex-wife, who was still listed on the beneficiary form, gets the money, even though the divorce court ordered her rights terminated and she signed a waiver. I really hope that everyone tuning in has a will in place. If you do, and I know that's a big if, then one point that is critical to reinforce with them is that their will provisions have nothing to do with how their qualified plan or annuity death benefit is paid out. Administrators, custodians, and carriers must stick to the four corners of their plan document, custodial agreement, or contract, regardless of what the owner's will says. So if your will says my wife gets X or my daughter gets Y, that's great. But it will have absolutely no bearing on how, for an example, the annuity company is allowed to pay out the death benefit. Again, in this case of an annuity, this is a contract, an agreement between two parties that is held separate and apart from the will. And the annuity company can only do what is provided for in the contract. So again, it is absolutely critical that everyone has a will. But clients must understand that the beneficiary designations on their annuity contracts are separate and apart from the will and cannot bootstrap off of the will's terms. So clearly, Bill didn't want the money to go to his ex-wife, but the plan administrator's hands were tied. The burden on Bill to change the beneficiary was low, and the exposure of the plan administrator was high if they paid out someone other than who was listed on the plan documents, but clearly not in line with Bill's final wishes. It is this kind of thing that happens a lot. So in response, a number of states, about 26, have created what are called auto-revoke statutes that automatically remove former spouses as beneficiaries from some accounts. These statutes generally apply to non-probate assets, assets that do not pass via will or under the supervision of a probate court. Examples of this include, but are not limited to, bank accounts, CDs, IRAs, annuities, life insurance, retirement plans, and trusts. Whew, that's a lot, but not everything. One thing that's important to remember, generally speaking, is that state laws cannot override federal laws that speak to the same topic. We call this the doctrine of pre-exemption. If a state tries to create legislation that is already covered by federal law, the federal law takes precedence. That concept is important to our next story. Hillman versus Marietta, U.S. Supreme Court, 2013. William Hillman was originally married to Judy. He had a life insurance policy through work as a federal government employee worth $124,000. He named Judy as sole beneficiary on the account. Warren and Judy subsequently divorced, and he later married Jackie. He never replaced Judy with Jackie as beneficiary on the life insurance policy before he died in 2008. But Virginia is an auto-revoke state. Judy filed a claim for the death benefit and collected the proceeds. Jackie sued, saying that Judy was barred from collecting the death benefit under the auto-revoke. So what do you think happened? The Federal Employees Group Life Insurance Act, which governs Hillman's group life policy and is by far the largest life insurance program in the world, states that the death benefit must be paid to the named beneficiary. The Supreme Court ruled that the federal law preempts Virginia state law. So Judy, the spouse of Warren, divorced 10 years prior, received the death benefit. Look, divorce is usually very difficult and very emotionally exhausting. By the time people are done with the formal process, they don't want to think about it anymore. Auto revokes can be helpful in cases like this, when a divorced spouse just wants to move on and might have forgotten to remove an ex-spouse as a beneficiary from the contract. As I mentioned before, the auto revoke state statutes may be trumped by federal law, but they are still a nice safety net nonetheless. However, you can't use that auto revoke as a security blanket either. As we saw with Hillman, these state auto revoke statutes may be superseded by federal law. It is important to reiterate that in this presentation is for informational purposes only. Nothing presented is legal advice and should not be construed as such. You should consult with a qualified legal counsel before taking actions in these matters. Here's another story where the failure to update beneficiaries, or more specifically, to name contingent beneficiaries, led to a very undesirable result. Herring versus Campbell, U.S. Court of Appeals, 5th Circuit, out of New Orleans. John Wayne Hunter was a retired employee of Marathon Oil and a participant in the company's pension plan. He was married to Joyce, who he named as the sole beneficiary on his pension plan. Joyce had 2 sons from a previous marriage, Stephen and Michael. By all accounts, John enjoyed a very close, loving relationship with his stepsons. He treated them like they were his own kids. Joyce, the sole beneficiary of the pension plan, died in 2004. John did not make any updates to his beneficiary designations. He did, however, update his will to leave everything to Stephen and Michael. John died in 2005. Because his only named beneficiary had predeceased him, and he had no contingent beneficiaries listed on the pension plan, the plan's terms required that the money be distributed in the following order of priority: surviving spouse, then surviving children, next surviving parents, after that surviving brothers and sisters or siblings, and finally, the participant's estate. So what happened? The plan administrator interpreted the definition of children under the plan to mean biological children or legally adopted children. This definition was clear, uniform, and objective, and facilitated the timely payout of claims. Unadopted stepchildren don't necessarily have any kind of bond or familiar relationship with a stepparent. How is the plan administrator supposed to know which stepchildren are close enough to a stepparent to count as children? There could be a lot of subjectivity there and a lot of differing opinions among family members on the quality of that relationship. That would make it very burdensome and expensive for the administrator to figure out on a case-by-case basis which stepchildren should be paid and which should not. It would have been much simpler and easier for John to make his wishes crystal clear, and by listing the boys as contingent beneficiaries when he added Joyce as primary, or added them as primary beneficiary after Joyce died, but he did neither. Ironically, if John did not have any siblings, then the money would have been passed on to his estate. Stephen and Michael, being the sole beneficiaries of John's estate, would have wound up receiving the money in the end. However, John's failure to update his beneficiary designations when Joyce died, either by neglect or under the mistaken assumption that the boys would have gotten the money by default, meant that his $300,000 pension benefit passed to his 6 siblings, who weren't even named in his will. And that brings us to the issue surrounding naming your estate as beneficiary on your annuity contract, either deliberately or by default. This is not to say that naming your estate as beneficiary is inherently a bad idea. Again, had John in the previous slides named his estate as contingent beneficiary on his pension, it would have bypassed his siblings and the boys would have gotten the money. However, it often seems that leaving your investment accounts to your estate is the easiest, simplest, and most straightforward option. Leave it to my estate and lump it all in with my other assets and let my will straighten it out is the thought. Probate serves as a formalized way to ensure that estates in a decedent's estate are properly distributed with full transparency. However, probate can be time-consuming. Average length on a straightforward estate is 6 months. It can be years depending on the size of the estate or if anyone contests the will. Money is tied up during this time. Some money can be released for essentials, but it usually involves more court costs and attorney fees. It's also expensive. Court fees, appraiser fees, attorney fees, executor fees, etc. If you ask an estate planning attorney, the conventional wisdom is it will cost anywhere between 3 to 8%, but on average about 5% of the estate. That will vary by state and by the complexity of the estate, but with a few exceptions, all of these costs come out of the state before any heirs are paid. It's not confidential. Once probated, your will becomes a matter of public record. Anyone can go to the courthouse and read it. If an heir needs emergency access to cash and the court requests financial documentation to prove the need, that also becomes public record as well. It opens the door to disinherited heirs and creditors to insert themselves into probate proceedings. Finally, with respect to annuities, annuity death benefits don't pass via probate. They pass via contractual agreement between the annuity carrier and the contract owner. This is usually much faster, cheaper, and more confidential than the probate process. Also, with regards to IRAs and non-qualified annuities, Estates cannot stretch. So when naming your estate as beneficiary on your annuity, your IRA, your pension, or any other investment account, you need to ask why. Why am I taking assets that will pass to my kids quickly, cheaply, and privately instead opt for the slower, more expensive, and less private option? There are many good reasons. You may have wishes in your will that cannot be accommodated by a one-page beneficiary form. But frequently, too frequently perhaps, when I ask a client, why are you leaving your IRA to your estate instead of your spouse directly? Their answer is, I don't know. Or, my lawyer told me to, which is the same thing as, I don't know. Again, not giving legal advice and not trying to say that leaving to your estate is a bad idea per se. As I said before, there might be really good reasons for doing this, but we see a lot of cases where doing this did not wind up working out the way the client intended. As I discussed in the last slide, probate can be expensive. It can be time-consuming. It can subject your estate assets to unwanted and unnecessary scrutiny and exposure. Also, naming your estate as a beneficiary may result in the loss of more advantageous distribution options for your heirs. For example, your spouse. Here we have a story of Larry and Jane. Larry was the owner of a $400,000 IRA and left it not to Jane, but to his estate. Larry and Jane both had drafted sweetheart wills, whereby one spouse leaves everything to the other and vice versa. So Larry's will left everything to Jane. Larry figured, I'm leaving everything to her, so if I leave the IRA to my estate, it will pass to her anyways. And that's true. It will pass to her eventually. But it will not pass to her in the way that either Larry or Jane would have preferred. So when Larry died, what was Jane able to do with the IRA? Can she roll the IRA into her own name? No, she cannot. She can only do that if she was named the beneficiary on the IRA. Can she take the account as a beneficiary and stretch it? No. For that same reason, she wasn't the beneficiary on the account. The estate was, and the estate cannot stretch. What about just cashing it out as trustee and having the IRA custodian issuing a check in her name? No, the estate was the beneficiary, and so the $400,000 has to go through the estate before it gets to Jane. And since estates cannot stretch IRAs, the options are a lump sum distribution or take it out over 5 years. Remember, estates pay the top tax bracket of 37% after only $12,750 in 2019 of income. So, the estate will be paying 37% either way. That means rather than getting more years of full tax deferral via spousal rollover or minimizing the taxes via required minimum distributions or RMDs, it's 37% on the $400,000 distribution. That's an upfront $148,000 tax bill. And this is only after Jane's had to go through the probate process. Time, expense, and public knowledge of the estate just to get the money. Let's pivot now to non-spousal titling situations. This next story deals with something we see fairly frequently, non-spousal joint owners. Very often it's between siblings, business partners, or in this case, an aging grandparent and a grandchild/caregiver. Sandy, age 37, was a caretaker for her elderly grandmother, Virginia, who was age 82. Virginia trusted Sandy and wanted to allow her to share control of her finances, including a deferred annuity with $130,000 of cost basis and $200,000 of gain. This totals $330,000 for the value of the annuity. Virginia doesn't want to mess with the time, expense, and inconvenience of lawyers, drafting documents, getting signatures witnessed, and paperwork notarized. So she simply adds Sandy as a joint owner to the contract. This way, Sandy can take care of withdrawals from the policy as needed without bothering Virginia with forms to sign or other red tape. How do you think this played out? Naming Sandy as a joint owner is a gift, which admittedly is likely covered under heightened and unified gift and estate tax credit. However, adding Sandy as a joint owner is also a taxable event to Virginia, who essentially granted ownership rights to all of the contract value to her granddaughter. Virginia will receive a 1099 from this annuity company for the entire contract value, $200,000 of which, in this case, is considered lump sum ordinary income to Virginia. But let's say the deed is done and it's spilt milk, so we move on. And 5 years later, the account has now grown to $380,000. Sandy passes away suddenly in a car accident. The death of either non-spouse joint owner triggers the death benefit. There is no continuation option for Virginia, so she receives another lump sum ordinary income taxable event on the money. So on the money she neither wanted nor needed. Grandma could stretch this payment, but at age 85, her RMDs are huge. Here's another story. Mom and Dad wrote an annuity contract with themselves as joint owners and their son as the annuitant. The daughter-in-law was the beneficiary. Mom and Dad assumed that this was an owner-driven contract, meaning the death benefit would not trigger until one or both of the owners passed away. The plan was that Mom and Dad would take income for the rest of their lives, and then once they died, the death benefit would trigger and pay out the son as the surviving annuitant. Well, first off, the death benefit paying out to the surviving annuitant was not accurate. But what was worse was that the contract in this case was actually annuitant driven, meaning the death benefit triggers on the death of the annuitant, even if the owners are still alive. So what happened? The son dies in a car crash at a young age. Mom and Dad were still alive and still needed an annuity income. However, the son's death triggered the death benefit, which is payable to the daughter-in-law. So let's talk about that. So again, in an owner-driven contract, the mom and dad own the contract, the annuitant is the son, and the beneficiary is the daughter-in-law. So if we circle back to what we just discussed, this is what mom and dad thought would happen. However, their contract was annuitant driven. So this is actually what happened. The son's death triggered the death benefit, which was paid to the daughter-in-law. The daughter-in-law had absolutely no interest in gifting the death benefit back to her former in-laws. Apparently, they did not get along. So because of this, mom and dad did not receive anything, all because they did not know how the contract worked. They didn't know how that death benefit would be triggered, and they didn't know who the death benefit would be payable to. They instantly lost their main source of retirement income with no recourse against their daughter-in-law. Another point to discuss is what made the situation worse is since mom and dad were living owners of the contract and the assets were transferred to another person, they just made a gift to the daughter-in-law. Now the exclusion limits are so high they didn't actually have to write a check to the IRS for their gift tax. But nonetheless, they had to fill out a Form 709 documenting their gift to their now former daughter-in-law. Talk about adding insult to injury. What's even worse than that is that mom and dad were under age 59 and a half. So there was also a 10% penalty assessed to them, and they will receive a 1099 on the death benefit, including the lump sum taxable event on the gains. Yikes. Let's take a quick break from those flowcharts. In this next example, I'm going to discuss one that we hear a lot. It's not really so much of an error in terms of who the clients lists as their beneficiaries. It's an error in terms of communication. Whether you're talking about an IRA, a qualified retirement plan, or a non-qualified deferred annuity, there appear to be a lot of heirs who don't realize that these distributions are usually taxable. They often think it's similar to a life insurance death benefit, which pays out without taxes due. They also don't understand that there are tax-efficient alternatives to taking out all of the money as a taxable lump sum, that these tax-efficient distribution methods must start within a year or so after the death, and they often can move the death benefit to another annuity carrier that can better suit their needs. We asked some wholesalers to share stories that they have personally seen in this regard, and the consequences of being uninformed or underinformed can truly be unsettling, particularly for heirs who wound up with a giant tax bill they were not expecting. So let's go through some of these. Similar stories, but different amounts of money. But the advisor/beneficiary never had a conversation about choices at death. 16 months after death, and they would like to do something. Too late. Now you're stuck with a 5-year payout. Again, remember, circling back to what I just said, you have to make a decision within about 1 year of the date of death, or you're stuck with the 5-year payout option. One major area that I see an issue when a person doesn't realize that they can do a 1035 exchange. I've had clients that take a lump sum around a $600,000 death benefit with a $200,000 cost basis because they didn't know a 1035 was available. They just lump summed it and paid taxes on all the gains, which is $400,000. That's not good for anyone, except maybe the IRS. A parent left a non-qualified or non-retirement annuity to an adult child. The beneficiary was not informed on the ability to execute a deceased 1035 and took a lump sum of $3.1 million with a cost basis of $1 million. Yikes, that's $2.1 million due in taxable income. I have heard many stories like this. They just vary a little. Let's discuss a case we came across a while back. Mom owns a non-qualified annuity worth $600,000. She is also the annuitant on her contract, and her beneficiaries are her 2 adult sons, Brian and Trey. She lists them equally at 50% each. Trey lost the use of both of his legs and one eye in an accident. He was collecting both Social Security income and Medicaid. Mom knew leaving the death benefit to a disabled son was a bad idea because receiving that money would blow up his benefits, and she intended to fix it by setting up a special needs trust for Trey and naming the trust as beneficiary in place of Trey. Well, that was probably a very good idea. The problem was Mom never got around to doing it. Remember what we said earlier about the big difference between knowing to do something and doing something? When Mom died, the 50-50 beneficiary designation was still in place. Trey knew that accepting the $300,000 would disqualify him from receiving benefits for many years. Upon advice from a financial advisor, who in retrospect did not know a lot about the Medicaid law and special needs planning, Trey disclaimed his share of the death benefit so that 100%, the full $600,000, passed to his brother Brian instead. Trey would not recognize any income and would not acquire any resources, and therefore should be able to maintain his benefits. And Brian would just slip the money to Trey as needed under the table. So what actually happened? While the disclaimer worked for state and federal income tax purposes, it did not work for state Medicaid purposes. As a named beneficiary on the contract, Trey had a vested right to access his share of the money. So it was his asset, his resource that he could have used to pay for his medical care. The disclaimer didn't erase the fact that the money was, if only temporarily, his. And by disclaiming, all he did in the eyes of Medicaid was make a gift to Brian. So Trey disqualified himself from government benefits, and he had no money to show for it either. Brother was holding all the cards, so not only did he have to rely on his brother to help with his care, he lost his government benefits he was receiving to boot. This presentation is not intended to be a primer on how special needs individuals may avail themselves of government assistance such as Medicaid and Social Security insurance. Suffice it to say that these government programs are available to individuals with disabilities and can cover a wide range of medically necessary services. The rules surrounding these programs can be complex. If the goal is to make sure that the special need individual qualifies for government assistance, one must be very careful when leaving a death benefit to that individual. These benefits are really intended for individuals who do not have the resources to pay for their own care. So let's review. Regular beneficiary reviews are a critical part of the financial planning process. Failing to perform these reviews on a regular basis can lead to your final wishes going unfulfilled, especially after large life events such as marriage or divorce. These reviews can ensure coordination of legacy intentions across all of your accounts and assets.
Thank you for joining me today. I hope you found the presentation insightful and interesting. My hope is also that it spurs you to take action and review your own beneficiary designations to ensure that they are the way you intend them to be. Thank you again for the time, and tune in next month for our next webinar.